Mallory is here because we just finished a series of interviews of 40 people who are sort of done ballot measures and are stakeholders and are considering it. And one of the things almost everybody says is how challenging it's been for nonprofits to feel like they can get engaged in this work. Now, some of it is hesitation because people don't want to offend their funders, but a lot of it's like, hey, we can do this work. This is not only legal, it's our responsibility. It's very important. So Bolder Advocacy, they are wonderful. They are the people who are helping us see that we can do this work. And I just, Mallory, I just read your little write-up on the website. So Bolder Advocacy, by the way, is an arm of the Alliance for Justice. She has a very impressive resume, by the way. She went to UC Berkeley Law School. That's Bolt, right? Yeah, Bolt Law School, and has had a lot of legal experience, both in the private sector and in the social justice sector. And come on, she was just because I didn't know what it was, but it sounded really important, the editor-in-chief of the California Law Review. I was like, wow, that sounds really important, and was selected as a Northern California Rising Star. I'm not sure what list that is, but so anyway, I'm just thrilled that Mallory is here, and she has a lot of expertise, and she's going to help sort of walk through what nonprofits can do in terms of ballot measures. But then it's open season for everyone to ask Mallory questions about other things besides ballot measures. Do I have that right?
Yeah, that's right.
Okay.
All right, should I kick us off? All right, Margaret, thank you so much for that very kind introduction, and you have me blushing over here. For folks who don't know me, my name is Mallory Morales. I am an attorney with Bolder Advocacy. I'm here in the Bay Area. I'm in Oakland, so love a room full of California folks. We're just in better moods because we got it good over here. Let me share my screen first because I do have a slide. And to answer your most important question, yes, you will be getting a copy of this slide, as well as any relevant resources from us. Can I just get a thumbs up from someone that they can see the slide that I have shared? Okay, amazing. Okay, great. And so as Margaret said, this is a good size group, so we can answer questions throughout. Feel free to raise your hand, take yourself off mute. You can also use the chat. I'll be monitoring that as well if you're feeling mic shy and want to ask your questions that way. So I am an attorney. At Bolder Advocacy, we do not form attorney-client relationships. What we do is a legal education and technical assistance. So what does that mean practically for today? It means that I will not be providing legal advice that can be relied on as a defense. We're going to give you the rules that apply to your organization and kind of clarify the law. It also means that our conversation isn't protected by attorney-client privilege. Of course, I'm not going to, go around saying what any questions you asked or anything like that, but I just want us to be mindful because in some ways this is a compliance training. And so we want to make sure that you know the rules that are going to apply to your organization as you think about getting engaged with the ballot initiative process here in California. And I'm super excited that you're all here today and either getting involved or thinking about getting involved. One way to think about compliance is that it's a strategy, right? So if you are compliant, then you can really focus on what your actual mission is, which in this space is getting, a ballot measure passed, or perhaps in getting engaged in opposing a ballot measure. Okay, so Margaret already did a great introduction about Alliance for Justice and Bolder Advocacy. So we offer workshops like this. We also offer public webinars. So if after today you think, hey, this is a great training, my staff needs to see this, let's be in touch. We have a ton of free resources on our website, and the free services we provide also is technical assistance, meaning that after today, if you have questions about the rules that apply to your organization and in the universe of nonprofit advocacy, please contact us. You'll get in touch with a lawyer, me or one of my colleagues, and we will guide you through these rules and try to demystify this process. So please use us. We are a nonprofit for nonprofits. Okay, so what are we going to be talking about today? We're going to be looking at some kind of big picture and upfront considerations. We are going to talk about some IRS basics around ballot measure rules, because if you are here on behalf of the C3, there's some IRS considerations to pay attention to. And then we're going to talk kind of big picture about California ballot measure rules, because there's state laws that are going to apply to your ballot measure activities as well. And that's not C3 specific. These California disclosure rules apply to all organizations. Okay, so let's talk about some big picture concepts here. So ballot measure advocacy in California really exists in two different realms. There's the rules that exist and are enforced by the IRS. So this is for C3 public charities. If you're here on behalf of like an affiliated C4, there's also some IRS rules to pay attention to. And the rules that exist and are enforced under the Fair Political Practices Commission, or the FPPC. So we're going to be really talking about two agencies that might have a role in your compliance strategy, right? So starting with the IRS rules, and we're going to kind of do a deeper dive, but I just am trying to set who are the main actors here. So the IRS. So ballot measure advocacy, so expressing a view about a ballot measure, is considered direct lobbying. So the good news is that 501c3 public charities can lobby. So if you ever hear anybody saying a public charity can't lobby, they're wrong, and send them our way, because we are trying to debunk that first myth, right? The IRS says that C3 public charities can engage in lobbying advocacy, and that's going to include ballot measure advocacy. For C3s, they just need to be mindful of their lobbying limits, and we're going to talk a little bit about that, and make sure that they're reporting their lobbying activity to the IRS on their 990s. Most of what we're going to talk about is like C3 rules about limits, but again, if you're here on behalf of a C4 and you're thinking of doing advocacy in your C4, again, it is lobbying. C4s don't have these limits on lobbying. That's one of the benefits of C4 advocacy. And so, yeah, so just understand, like, where are you housing this work? If it's in your C3, keep in mind that there's lobbying limitations to pay attention to. There's also restrictions about partisan political activity. And partisan political activity, as the IRS views it, is supporting or opposing candidates for office. So candidates for office, right? So not ballot measures. So you can influence how folks vote on ballot measures in elections, but you can't, as a C3, influence or tie that ballot measure advocacy to a candidate. So if part of your ballot measure strategy is going to be aligning it with a certain candidate for office, let's say you got a city council member who's really supporting your ballot measure, any kind of alignment there that could suggest to the public that you also have a favorite candidate for office, that is C3 prohibitive. You have to do that in your C4 if you have a C4, or really think about what your strategy is going to be if you only have a C3. So under California law, there are no limits to lobbying in California. So California is not about limiting an organization's lobbying activities, but you may have to register and report the activities that you're doing. So the ballot measure work, unlike the IRS schema, is actually under campaign activities. It's considered campaign finance rules, right? So your first big takeaway is that there are different set of rules in California for state, city, and local ballot measures. So it's also going to be important to look at your relevant local jurisdictions. and their campaign finance entities to see whether or not there are also corresponding rules that are going to happen at the local level. Okay, so we're gonna dive a little deeper into both of those topics, but I just wanted to make sure you understand kind of the two actors here. And whoa, Marina, your camera is like glitching. I don't know if anyone else is getting that, but okay. Okay, so okay, with the knowledge that the regulation of ballot measure work falls under IRS federal law and the FPPC, here are just some like questions that are some upfront questions you want to ask yourself before you figure out what your strategy is, right? So the first question, oops. Okay, have you made the 501H election? So this question falls under the IRS umbrella of laws. So the 501H election is a way that the public charity can track and report their lobbying based on lobbying expenditures. So how your organization is spending its money on advocacy related to ballot measures. Again, I'll also add that lobbying is not just, you know, confined to ballot measure activity. It's really anytime you're influencing legislation as well. But we can have another conversation if you're doing a lot of legislative advocacy. So by making the 501H election, your public charity can have a streamlined way to measure its lobbying expenditures. And it can actually make reporting under California law easier too, because if your IRS reporting is in order and you're paying attention to how much money you're spending, because you have to tell the IRS how much money you're spending on this, you're going to have data and information that you know about how much money you're spending that might need to be reported to California. So having kind of a singular system of tracking your advocacy dollars is going to be important. And so making the 501H election for public charities is going to be one way to kind of align those two tracking systems. So the next is, are you coordinating with a ballot measure committee? Coordinating means that you are working together with a ballot measure committee, right? So there are a lot of advantages to coordinating with ballot measure committees. If you do so, right, the ballot measure committee is likely going to be the entity that's doing the reporting to the FPPC, so doing the California state law reporting. And so your responsibility is going to be reporting accurate information to the ballot measure committee so that they can report to the FPPC. So that's another question you want to ask yourself. Are we coordinating? The third question you want to ask yourself, are you raising money that is earmarked to support or oppose a ballot measure? Earmarked means that you're receiving money where there is an agreement that that's what that money is being used for. And earmarking can happen in writing, it can happen verbally, right? It's just that there's some kind of a mutual agreement between the person giving you the money and the person receiving the money about how that money is going to be spent. So if you're getting money and the purpose of that money is to support or oppose a ballot measure, and you're storing that money in your organization's coffers, right? So you're going to want to make sure that you understand the rules around reporting, because raising earmark money might trigger some disclosure requirements. And if you're trying to avoid disclosure requirements, you might want to think about minimizing, avoiding raising earmarked funds. But we can talk a little bit later about like some strategies if you're trying to minimize reporting requirements as an organization. Finally, do you have non-donor funds to support this work? So when I say non-donor funds, I mean money that came to your organization that wasn't, donated, right, through a foundation or through an individual donor. So let's say you have funds that come in from other revenue streams, like, I don't know, rent payment or something like that. Because if you're using donor funds to support your ballot measure work, which is very common, you may have to disclose donors. So one strategy, one way to think about easing reporting requirements is to see if you have any non-donor funds. I know that's kind of a hard way to it's easier to find donor funds, right? So, but just something to think about. So again, these are just upfront considerations. I raised a lot of issues that we're going to go do a deeper dive in, but these are the questions you want to ask yourself before you start engaging this advocacy, because it could trigger some requirements. Okay, so let me pause there. See how we're all doing. I see folks taking notes. We got such good students here. Okay, let's talk about IRS rules. But again, if you have questions, just go off mute or raise them in the chat. Okay, so we like to start with this.
Please feel free to just sort of shout out a question.
Yeah, absolutely.
You know, yeah. And this should not feel like, oh my God, I can't do this. This should feel like, oh, that's pretty simple. We can do that.
Yeah, exactly. Okay, so let's look at this chart. And so we like to use this chart to kind of show you like the nonprofit cinematic universe and how this apply and how the IRS treats different nonprofits. So you know, I mentioned this in the beginning, you know, the main players in this space are going to be C3s, which are public charities. And this could also include community foundations as well. So if you're a community foundation, you know, you're being treated as a public charity. There are different rules around private foundations. I don't think there's any private foundations in this room. Okay. In the other column, we have C4s. These are social welfare organizations. You know, my nonprofit, Alliance for Justice, has an affiliated C4. So you might see organizations that have affiliated C4s that usually have like action in their title. C5s are labor unions, and C6s are trade associations. So these are the different types of tax-exempt organizations that you're going to see engaging in advocacy. And we group like labor unions, social welfare orgs in the same bucket because they kind of have the same treatment. So what treatment is that? C3 public charities. They're tax exempt. Woohoo! They don't pay income tax, and they have this added benefit of tax deductible contributions that you can offer your donors. So the IRS says that the trade-off, right, is that as a public charity, you can engage in lobbying, but it is limited. We are going to limit your lobbying, which is going to include your ballot measure activity. And you can't support or oppose candidates for office. And that's broader than like endorsing candidates for office. The way the IRS determines whether you're engaging in electoral activities is based on a facts and circumstances analysis, such that the context around your communication, if it could imply that you have a favorite or least favorite candidate, you know, that could be considered influencing elections. So just be mindful of that. And we have resources on that activity as well. C4s have a little more wiggle room. So C4s can do more, can do everything a C3 can do and more, right? So they don't have this benefit of tax deductible contributions, and C4s do need to disclaim that when they're raising funds that their donors can't, you know, deduct that donation from their tax returns. But what C4s can do is engage in unlimited lobbying. So that's going to be a consideration for where you're doing this work, right? If you need to engage in the level of ballot initiative advocacy where you're coming right up against your lobbying limit, maybe it makes sense to do this with a C4, right? And there's this other benefit, which is that C4s can do some electoral activity. They can do endorsements, they can influence elections, but it has to be their secondary activity. And so it can't be the only thing that the C4 does. And the split of like what is secondary and primary activity for a C4 is like, it's like 60-40. You know, so 60% of the C4's activities need to be nonpartisan, and nonpartisan includes lobbying activities. And then like 40% can be partisan. So Samantha, I know there's a question in the chat, and Samantha, you have your hand up. So let me start with Marvin. So with electoral activities, can C3s support key ordinances? So yes, so great question, Marvin. Exactly. So C3s can outright support ballot measures, because ballot measures, the way the IRS views them, is an example of lobbying, not an example of nonpartisan political activity. And the difference there is that C3s can't support candidates for office, but with ballot measures, it's kind of an interesting definition that you'll see in the next slide, which is like they view the public as legislators. So if you're telling the public to vote on a law, you are engaging in legislative advocacy, which is well within your right. Samantha, I see your question, your hand.
The question was very similar. It was, let's just say we have a city council member who is running for office when the ballot measure is going to be voted on and they endorse it. Would that show any, or would that allude to preference over another candidate if the other candidate didn't endorse it? How would you see that situation?
Yeah, that's a really good question. And you know, when you have folks on your C3 staff that are engaged in candidate elections, you know, either they're the candidates themselves or they're like working on a campaign, they need to keep those roles really separate. So, you know, they can do whatever endorsement in their own capacity as a candidate, but like, you might want to make sure that there are policies in place that they're not using the C3's name, of, you know, and banking on that like affiliation, because the C3 doesn't want to be tied to, you know, you don't want to be tied to supporting their candidacy. So we actually do have resources on election time policies for employees who might be like running for office. And so, yeah, I think like the best practice in that case is making sure those hats are really separate. Did you have a follow-up question?
No, I think my question was, if this is not in reference to a nonprofit, it's more in reference to a campaign, right? So let's just say the campaign or the ballot measure, they get an endorsement from someone in public office who is up for re-election. And a nonprofit is thinking about endorsing that ballot initiative, and the council member endorses the ballot initiative. Would that show preference in terms of like if the nonprofit therein supported or endorsed that ballot initiative?
Got it. Yeah. So the nonprofit, so the nonprofit is a C3?
Yes.
Yeah. Okay.
And
yeah.
then the council member would be their own.
Yeah. So the C3 can endorse ballot measures. That is they're allowed to do that. I think the thing that you are maybe pointing out is like, if the city council member is also endorsing the ballot measure, you know, is that going to be perceived as you supporting the politician, right? So basically the answer is no, right? Unless there's like more context suggesting that you're really aligning both of those campaigns. So as a C3, in order to kind of stay nonpartisan in your ballot measure advocacy, you want to stay focused on the ballot measure itself and the issues of the ballot measure, not on, you know, who else is supporting it, you know, who's also campaigning, if that makes sense.
Mallory, can I ask a question about a C4? A C4 can run the campaign, right?
Mm-hmm. Yeah.
A C3 can't.
A C3 might be able to, but there's going to be lobbying limits. So yeah. So I mean, if you mean like housing, like being the housing, like the house for like, yeah, it's probably not going to be practically feasible given that there are lobbying limits for a C3. So let's talk about what those lobbying limits are.
Let me just give it there is going to be a campaign in Pomona, and they decided it's a C3 nonprofit, and they decided to start a C4 too at the same time so that they can, you know, be more engaged and in control of the ballot measure campaign, just by the way.
Yeah. Yeah, and we often see that strategy. Again, which is not to say that it's impossible for a C3 to house the ballot measure, but the lobbying limits that the IRS imposes need to be considered. So, so let's talk about what those lobbying limits are, right? So I've mentioned there are limits. So if you are an electing charity, meaning you've made the 501h election, that your dollar, it's going to be a dollar amount that is your lobbying limit based on your organization's exempt purpose expenditures. So if your C3 spends $500,000 or less in a year, you have a lobbying limit of 20% of that. So that's how much money you have to spend on your lobbying, on lobbying activities, include that, and that includes direct lobbying. So that's why one of the first considerations is, are we an electing charity? And if the answer is yes, then you need to figure out what your lobbying limit is. And we do have a calculator on our website. I'll circulate a resource that shows how to figure out what your lobbying limit is, because you need to make sure that for the IRS purposes that you're staying within your lobbying limits. If you're not an electing charity, that means that you're in the insubstantial part test. And that what that means is that you only an insubstantial part of your activities can be spent lobbying. And that limit is lower. It's like 3 to 5% of your organization's activities. So if you don't know whether your C3 is an electing charity, you can check your 990s. Whoever fills out your 990s, they may know. It may be that you need to submit a form to become an electing charity, and that is a half-page form. It's the easiest form you'll ever fill out with the IRS. You just like send it to the IRS, certified mail, and then you're in the club. You are now an electing charity. So I will also send a resource around about how to make that election, because it's really the easiest way for you to for your C3 to maximize its lobbying capacity. Again, this is if you are if you're doing most of your ballot measure work in the C3. You need to be mindful of that, because again, the C4 doesn't have lobbying limits.
Mallory,
Yes.
just to clarify, when you elect to be an electing charity, is that the same when you refer to electing the CH designation?
Yeah, it's the 501H. Yeah,
501H.
Yes.
So the lay person's is electing charity.
Yes. Yeah. Thanks for making that point. Yeah, I'll use those interchangeable, but yeah, I'm talking about making the 501H election. Yeah. Any other questions about making that election or that limit? Okay. So, okay, so let's say you've made the election. And now you have your C3 has a lot of room, to engage in lobbying. So what is lobbying as it is defined by the IRS? There's 2 types of lobbying, but when we're talking about ballot initiatives is an example of direct lobbying. So direct lobbying is when you're communicating with a legislator and you're expressing a view about specific legislation. So what's kind of, funky about the ballot initiative is that meets the definition of direct lobbying, right? You are communicating with the general public, and the general public in the IRS's eyes in this context are like unpaid legislators, which, makes sense. The ballot initiative is about direct democracy. So they're voting on the laws. So if you're going to be communicating to the general public about ballot initiatives, and also even before it gets on the ballot, if you're collecting signatures, the IRS says that signature collection is you communicating with legislators, expressing a view about specific legislation, because think about it, you're trying to get the public to get this law on the ballot so then they can then vote on it. So the clock for measuring your direct lobbying starts at the signature gathering process. So you want to make sure that you are documenting the expenses. Again, the 501H election is about how much money your organization spends. So if you have paid staffers to collect signatures, you need somebody in your accounting department to figure out what the dollar amount is of how much your organization has spent on this direct lobbying activity. So it's going to be signature gathering. It's going to be, communications, your lawn signs. If you are posting on the website and creating graphics, vote yes on measure so-and-so, or vote no, right? Those are also lobbying communications that need to be counted. And so why are you tracking this? Because your 990, the form that you fill out to the IRS every year, will ask you, did you lobby and how much lobbying did you do? So that's why we're keeping track of these amounts for IRS purposes. There are 2 definitions of lobbying. I said there's also grassroots, and this is grassroots lobbying, which is communicating with the general public expressing a view about specific legislation with a call to action. So you're encouraging the public to like call their senators. This is not really a definition that applies to ballot measures. Again, I said ballot measure advocacy is an example of direct lobbying, but I do want to make sure that you know that there's also grassroots lobbying that counts towards a limit if you're engaged in other types of legislative advocacy. So any questions about these definitions and how they're going to apply to ballot measure advocacy or any other questions?
There's
Oh,
a question in the chat.
Yeah. Do you have any advice on navigating SB 1494 regulations? Okay, so Courtney, do you want to tell me a little bit more about what you're referencing?
Yeah, so it's just been interesting navigating because it's my understanding that contributions going towards a candidate, even from a personal perspective, it's required that you list your employer, but there's a cap on how much contribution can come from a specific entity or employer tied to multiple employees, and the cap is extremely low at like $250. And now we see some enforcement locally, so there's like an opt-in on for example, like public comment documentation at city and county public meetings. So just curious if you have any advice on that. We've had like some interested workarounds in like listing partners on contribution forms and working through understanding what like more PACs look like. But it's kind of a conundrum in supporting fundraising for candidates, not tied directly to like C3 operations, but even from a personal perspective.
Yeah, I mean, I think, I don't have any specific advice about navigating those I'm not super familiar with those campaigns because we mostly are in the C3 space. So we're not, we don't offer too much information about like campaign contributions, to candidates. But I can circle back on that and talk to my colleagues and see if we have anything on that. But that's a good question. Okay, so when our agency shares a Facebook post from a state organization / association we belong to as a call to action advocating for passing a budget, trailer bill, or any other piece of legislation, should we be claiming this as lobbying? Okay, so this is a great question, Carrie. It's not dumb at all. We go through this like in our lobbying 101 trainings. So the answer is yes. So that's a good reminder that everything that you post on your social media, including reposting, that counts as your own communication according to the IRS. So 2 things to be mindful of. If you're going to be reposting like some really great graphics and it also has partisan political information, do not repost that on your C3. If you're reposting lobbying communications, for example, like, yeah, like there's a an image like this, vote yes on Measure J or something like that, and you just want to hit repost, you will need to account for that in some regard. And I recognize that it takes like a nanosecond to hit the repost button. So every organization has their own their own strategy for how they account for that. It can be as simple as, you sit your whoever is in charge of your social media, estimates, how many minutes it took, and they put that in a timesheet somewhere. And we do have resources on how to track lobbying activities as well. But yeah, that's a good point, Carrie. So thanks for raising that.
Can I ask one quick follow-up question about that?
For sure.
If it's something more general, like it's less a specific piece of legislation and something more general, like reposting things or sharing things that are about advocating for an increase in childcare funding, that would not be lobbying, right? Because there's no specific measure that we're asking anybody to vote on. We're just asking generally, please take action on this issue.
Okay, yeah, so that's a good point. So that example that you're talking about would be like a grassroots lobbying communication. So you're because you're sending this to like the public. Is that right? Like,
yeah, like if we were posting something about the need to increase childcare funding, like on our Facebook and.
Okay, yeah. Yeah, so what is missing from the slide is that a call to action is pretty is 4 things. It's 4 specific things. A call to action is telling the general public to contact their legislators. It is giving the general public contact information of their legislators. It is giving them a mechanism to contact their legislators. So for example, like if you link to a petition and that petition is going to go to like city council or something. And then the last one is like identifying by name the legislators who are going to be voting on the proposal that you're advocating for or against. So in the example that you provided, right, if you're saying, even if you're talking like specifically like, or pretty generally, like, we want more, I don't know, resources for our schools. If you are talking to the general public and you're giving them a call to action to contact their senators to ask for that, that's going to count as lobbying. So yeah, so you want to kind of treat these definitions as like a checklist, and walk through that checklist to see whether you're doing grassroots lobbying or direct lobbying. Good questions. Okay, so let's move on, but if you have other questions, don't hesitate to drop them in the chat. So the other rule that the IRS needs to be, that you need to be mindful of under the IRS, right, is that 501c3 public charities need to be nonpartisan. So this is kind of what we were talking about before. So when we engage in ballot measure work, if you are a C3, it needs to be done in a nonpartisan way. So examples of nonpartisan ballot measure work: circulating petitions, endorsing measures, registering voters. That's all well within your rights as a C3. Even just telling voters how to vote on the ballot measure. You can take firm stances on ballot measures, and that's nonpartisan. When do you creep into partisan territory? When you start aligning your organization's position with a candidate or a political party. So this was the example that Samantha brought up, right? Like, it's okay if there's also candidates for public office endorsing those ballot measures that you're endorsing, but you want to make sure that your messaging doesn't, that you're not saying like, hey, we're so glad that this candidate is also in support because we support that candidate too, right? So this image here, Bernie says yes on 61, like that is completely okay for a C4 to do. For a C3, you want to avoid it because once you start aligning those positions, what you're communicating, according to the IRS, to the public is that you want the public to vote yes on this ballot measure and yes to this person, right? So make sure we keep that separate. I know that we rely a lot on coalition work to do, our advocacy. So if you are doing coalition work with organizations that have different nonprofit status as you, so you're working with C4s or labor unions, you need to make sure that your tax status is following you around. So if you're on a C3 and the coalition meeting is like, okay, how do we have this like really partisan, like a rally where we're also highlighting these candidates that we're endorsing, that needs to be a signal to your C3 that maybe you don't participate in that activity. You have to make sure that you're doing C3 permissible work, even when you're working in coalition with C4s. Or labor unions, for example. Okay, this is a reminder that C3s can also engage in voter registration and get out the vote efforts as it is related to an election. So the IRS says you can't support or oppose candidates for office, but you can sign people up to vote. You can do so, and you can also encourage them to vote for a ballot measure. You want to make sure that you are engaging in voter registration, and that you're registering all members of your constituencies, or you are targeting folks for nonpartisan reasons. So if your C3 is going to do voter registration, to be nonpartisan, you basically cannot be targeting like certain communities because you think they're going to vote for candidates in a certain way. Now you can target communities for being like historically underrepresented at the polls. So if you are, focusing your voter registration efforts on like young people or people of color, the IRS said that in and of itself is not partisan targeting. If you're targeting a community because you know that they're a swing district and you want to get them all signed up, right? Then now we're thinking, and you think that's going to outcome the influence of a candidate election. Now you're doing it for a partisan reason. So that's kind of just one way to think about, like, the IRS is looking at all of the facts and circumstances around your actions to determine whether you're engaging in partisan political activity. So there are some barriers to be mindful of. Any questions about like nonpartisan or examples that folks want to hear about? Okay, so those are the guide rails for IRS, right? If you're a C3, you need to make sure that you're tracking your lobbying and that you stay within your lobbying limits and that your advocacy is non-partisan. And if you're a C4, remember that you can engage in unlimited lobbying and you can do some partisan political activity. You also need to record that so that you have documentation that you are not solely doing partisan political activity. Again, it has to be a secondary activity. So just make sure that you're balancing that advocacy as a C4. Okay, so that's IRS rules in a nutshell. And again, we usually do like a 90-minute training solely on those IRS. So we did zoom through it, and we will circulate some resources on the IRS universe. But let's talk about the state rules that are going to apply to ballot measures. So again, the key thing to remember here is that the state rules, the California rules, are about transparency, right? The FPPC is tracking money in California elections. So it's about disclosing money spent and raised to influence a ballot measure. It's not about limiting your activities, right? Okay, so what does that mean practically speaking? Is that these rules are about filing the required paperwork with the required agencies. It's not like, yeah, it's not super fun or exciting, but it is important that we understand, what is going to trigger those reporting requirements. C3s are not the only, it's not, and these rules also, they don't apply just to C3s. They're going to apply to all entities that will have to file reports with the California Secretary of State. And they're gonna publicize that information. Okay, is a separate account needed if we want to raise money? Okay, yeah. So Margo, we're going to talk about earmarking in a bit. That might answer your question, but yeah, let's revisit that. Okay, so the California ballot measure rules are about transparency. And the California's campaign finance rules apply only to committees. And so that's going to be like the first determination is like, do you qualify? Are you now a ballot measure committee? And I'll also note that California's campaign finance rules apply to candidate committees also, but we're talking about ballot measure committees right now. So okay, yeah, so you already know that you can't be a candidate committee as a C3. That's already prohibited under the IRS. So that's, if you're a C3, you're not a candidate committee. The IRS is going to prohibit you from doing that, but you can support or oppose ballot measures. And that means that you could become a ballot measure committee. So generally a ballot measure committee is a person, a group of people, or an organization that raises or spends a certain amount of money to support a ballot measure committee. And once you become a committee, you have to register within 10 days of qualifying. You have to pay an annual fee to the Secretary of State. It's like $50. And then you have to report according to the committee that you are. So as you can see in red, you can become a committee without intending to become a committee. That's what makes this California law so fun for everyone involved. And I'm so glad that you're all here, right? Because you do want to know what's going to trigger committee reporting requirements. Because even if you're like, I didn't know I was a committee, the registration deadlines are kind of quick, right? So by being here and recognizing that there are triggers, like that's already like a huge like up to like compliance. So, Okay, so you become, let's say you become a committee, and we're going to talk about how you become a committee. There's basically two ways that you have to become two ways to become a committee. You are housing the main ballot measure committee. So you are like, we are the ballot measure committee. And then there's other ways that you can become a ballot measure committee. That's not, even if you're not housing. So, let's say that you are a nonprofit that houses the main ballot measure campaign. So you have created the committee. You were primarily formed to support a ballot measure. When your nonprofit houses the ballot measure committee, again, you're going to trigger those reporting requirements. So you need to register as a committee, and that your committee is going to be the main vehicle for accepting and spending money for that ballot measure. So when I say money, throughout this presentation, I'm not just talking about dollars, right? I'm also talking about goods and services as well. Okay, so what does the main ballot committee need to report? The first reporting requirement is going to be grants received. So this is not just money. It's also going to be any staff time and other non-monetary donations. You're gonna, Schedule A is where you're going to see this disclosure. So we kind of have this example of like this woman named Diana Alvarez. This is like an example we've used for years. So God bless Diana Alvarez, wherever she is. This is all public records, right? So here we see that Diana Alvarez contributed $100, and she had to be reported on this document. So again, if your organization makes a monetary contribution to the campaign of $100 or more, then the campaign will publicly disclose the fact that you contributed and that you made such a contribution. So grants received is going to be disclosed. Another reporting that will be disclosed on the FPPC disclosure paperwork is non-monetary contributions, or what we call in-kind contributions. So this is going to include staff time, any mailing lists that are being donated. So for example, here we have the ACLU Foundation of San Diego, which donated some staff time and expenses for this period, and it was valued at a bit over $7,000. So if your organization donates anything of value, it's going to be to the main ballot committee. That donation is going to be disclosed and reported. So in addition to the grants the campaign receives, the campaign is also required to report so the receipt of everything that's, and they're going to disclose the fair market value of what you provided. So the campaign, and again, the campaign may be required to report received donations from you within 24 hours. So it's important to understand these reporting rules before you donate anything of value to the campaign, because they might need to understand like what the fair value of that is. So it's going to be donations, funds spent on communications with non-members that express a view on the ballot measure as well. So this is all, again, requirements for the reporting requirements for the main ballot committee. Oops, sorry. Okay, what else is going to be reported? Other expenditures like staff time, expenditures for canvassing, phone banking, polling, any advertisements or leave behind materials, and any contracts that you have with other organizations to do outreach on this measure. So again, we have an example of campaign worker salaries, right? That is being reported. So it's going to be important for your organization to be tracking these expenses one way or another. either if you're planning on donating that time to the main ballot committee, or if you are the main ballot committee, you need to make sure that you are keeping good record of this. Okay, so if your nonprofit is not housing the ballot measure campaign, you may still qualify as a committee by receiving or spending money for or against a ballot measure. Okay, so this is like, so the ballot measure is not housing, right? So you can still qualify. If you are coordinating with the main campaign, you may also need to notify them about certain expenditures as well. So let's talk about ways that you can be qualify as a committee when you're not the main ballot measure. So main ballot measure committee. So we have the recipient committee. So how do you qualify as a recipient committee? If you raise or receive $2,000 or more in a calendar year that is earmarked for ballot measure work. Again, we talked about earmarking. So when you receive money and there is an agreement that that money is going to be spent on ballot measure advocacy, you need to start tracking whether you're going to hit that $2,000 threshold. So if you get $2,000 for your organization, that doesn't necessarily make you a recipient committee. Again, it needs to be earmarked. They have to be, here's $2,000 and I'm giving you this $2,000 to support your ballot measure work. And we're agreeing that you're going to take this money to support this ballot measure. The other way to become a recipient committee is if your organization spends $50,000 of donor funds over 12 months or more than $100,000 in 4 consecutive years. So this is regardless of whether that $50,000 or that $100,000 was donated and earmarked. So it doesn't need to be earmarked funds, but it does need to be donor funds. So it's going to be important if you're receiving money for ballot measure work, or you're going to be using donor funds for ballot measure work, to do some record keeping and really know how that money is being spent, at what rate it's being spent, and whether you're hitting these triggers. And again, I say donor funds, I'm again talking about funds that are being donated, right, by individual donors or grants. So if you're spending more than $50,000 in 12 months, but that $50,000 came from revenue from a different organization, from, I don't know, like rent or other sources of revenue, that's not donated, you're not hitting this trigger. So again, if you hit these triggers, you need to pay a $50 fee to the California Secretary of State and register as a recipient committee. And then you need to file these timely campaign statements that are going to include, your expenses. Most folks that are recipient committees are going to hire campaign finance treasurers, because you will need to identify your donors and report your donors. So that's going to be an important factor if you are thinking about donor relationships also, because again, let's say an organization gives you a donor gives you $50,000 or gives you money that you are using to spend on your ballot measure advocacy. If later down the line, they have to be reported as a donor, you want to make sure that you have that conversation with them so that they know that they're going to be disclosed in this. Yeah, so other things to know about recipient committees, they're going to file semi-annually, quarterly, and on pre-election statements when required. I have a slide later that shows like what the form is. And you're basically required to file reports until you affirmatively terminate your status as a recipient committee. So again, keep in mind that if you are not, if you're done with the ballot measure advocacy, you're not going to do it next year, you do need to file an affirmative form with the FPPC and make sure that you terminate your status here. So the next type of committee you can become is called a major donor committee. So you become a major donor committee if you contribute $10,000 or more in a calendar year to a recipient committee, but you don't receive any money, any earmarked funds for ballot measure work. So a major donor reporting, it's a lot easier to become, the reporting burdens are lower for a major donor committee than for a recipient committee, because again, you don't have to disclose your donors. You can, it is also possible that you can qualify as a major donor committee and then later qualify as a recipient committee. So even when you register as a major donor committee, because you hit that $10,000 mark, if you continue to spend so much that you hit the triggers for a recipient committee, you might need to file as a recipient committee later down the line. The last type of committee that we will cover is called the Independent Expenditure Committee. So if you spend $1,000 or more in a calendar year on communications that expressly advocate for or against a ballot measure, and these communications are not made in coordination with the ballot measure committee, then you may be an independent expenditure committee. So this is a pretty low threshold. And this is why, we were talking earlier that sometimes you become a ballot measure committee and you don't realize you're becoming a ballot measure committee. So if you are spending $1,000 or more in a calendar year on non-coordinated communications expressly advocating for or against a ballot measure, you're having a big media campaign, then be mindful of this trigger, right? So you might be an IE committee, and you'll need to file as an IE committee and make sure that you're filing the necessary disclosures for this one. If we're talking about, if you are not going to be housing the main ballot measure committee and you're not planning on coordinating with the main ballot measure committee, but you just want to do advocacy around these ballot measures so that you can educate your constituents, it would be very strategic, right, to not spend $1,000 on your own personal independent campaign, so that you don't have to trigger it doesn't trigger reporting requirements. So it's okay to be strategic and spend less so that you're not required to report. There's a lot of individual considerations as to whether you might have the capacity to meet these compliance deadlines. So if you're a smaller organization and you don't know that you're going to have the capacity to meet that, make sure you're staying under these spending triggers. Now, a note about independent expenditures, right? What does that mean? What does it mean to not be coordinating with the campaign, right? You are not, there is not an agreement between the campaign and you about what is being said, about the language. You're not donating money to the main campaign. So independent expenditures, like you're not talking to the campaign, right? Maybe you're taking an independent stance about, you want folks to vote for this ballot measure or this other ballot measure. The language in your communication is going to indicate whether or not you're advocating for or against a ballot measure. So if you have like public education materials, that doesn't express a view, you need to be mindful of this express advocacy language.
Mallory, there's a question, I believe, in the chat.
Oh yeah. I work for a private foundation that restricts the use of funds to non-lobbying purposes when not a GOS grant. What would you say to C3s about using private foundation funds in this ballot measure situation? Okay, so yeah, so ballot measure advocacy is going to be, and that is going to be an example of lobbying. So they'll need to use non-restricted funds for their ballot measure advocacy. Now, if you're not, private foundations, they can fund C3s that engage in lobbying activity through general operating support grants or through the project grant safe harbor. And through the private grant through the project grant safe harbor, you don't have to restrict your funds for non-lobbying purposes. But if there is a restriction, then that C3 needs to use funding from elsewhere for its ballot measure advocacy. That being said, it can use its private foundation funds for other activities, right? It can be used for educating the public about voting dates, or other activities around get out the vote efforts. So because ballot measure advocacy is likely going to fall under the definition of lobbying, C3s should not be using restricted funding. Yeah, absolutely. Okay, so let's talk about activities that aren't reportable, that aren't going to trigger any reporting requirements. So even if you don't have to report to California, remember that you do have to report all of your lobbying activities to the IRS. So don't forget about the IRS. But there are some exemptions, right? So the first exemption is limited staff time. So if your staff is spending 10% or less of compensated time in a calendar month, then that's not going to count towards those dollar thresholds that we looked at. So for each employee, you need to basically look at every employee individually and see, are they spending less than 10% of their time on ballot measure advocacy? And if the answer is yes, then you don't have to report their activities or count that towards those thresholds. So one thing to think about if you're trying to avoid triggering these California disclosure rules is, maybe making sure that your employees stay under this limited staff time rule, so that you're not hitting these reporting triggers. Another non-reportable activity involves newsletters. So, if you have a link on your website that says sign up for, our newsletter, if you limit your distribution of this newsletter to members, to people who have asked to be on your mailing list, you have a regularly scheduled publication date for these newsletters. Let's say they come out every Friday. Then you don't have to report, any ballot measure activity that's happening in your newsletter communications. If you are basically staying within a regular publication, the alternative would be, let's say that you didn't have a newsletter that comes out weekly, but all of a sudden, right up until the election, you are publishing a ton of communications pushing for a ballot measure campaign. Then that activity is going to need to be counted towards the dollar threshold that we looked at earlier. So again, newsletters is an exemption to that threshold amount. Next, we have member communication. So members in California, members of an organization are defined as people who have the right to vote on corporate decisions, pay membership dues, or designated in your articles by bylaws or members, by in your bylaws as members. So this is a pretty narrow definition. But if your organization has members that fall under this definition, then ballot measure advocacy communicated towards those members is, again, the amount that you're spending on member communications is not going to count towards those dollar thresholds that we talked about. In-office fundraisers is another exemption. So if the following is true, right? If the event is held in your office, if all money is raised and it all goes directly to the ballot measure, and the event itself is $500 or less, then that in-office fundraiser does not need to be reported by you or by the ballot measure campaign. It's not a lot of money. So this is a pretty narrow exemption, but it is something to keep in mind that if you're doing a fundraiser in your office, and it's a very frugal fundraising event, that's not going to hit the threshold or be counted towards the threshold. If the campaign hired you to do contract work, like go out and get signatures, you know, or do like polling, right? And you have a contract at fair that's being charged at fair market value. The main ballot measure committee will report this as an expenditure. So just something to keep in mind, that contracted services to the campaign should be recognized for their fair market value, or else they may be considered a contribution that's going to need to be disclosed. Okay, so I know this conversation in the chat, right? There's a lot of rules here that we have been talking about that could potentially trigger it. Trigger disclosure under California rules. And so what does that mean practically, right? So your organization, what that means is that you just need to track your spending and any in-kind contributions that are supporting or opposing ballot measures. And for somebody in the organization to be aware of how close you are to these reporting triggers in California. But again, these triggers, you know, if you are engaging in a lot of ballot measure advocacy, you might be triggering them. But you can, you know, you can design your campaign and your own advocacy to meet the needs of your organization. So when you are tracking your organization's spending and in-kind contributions, that's also important for you to do because you have to, at the end of the day, report it to the IRS. And so making sure that you have a good system for keeping track. You have somebody on your staff who knows how to account for all of these contributions and spending is going to be important. You want to decide early, right, if your organization is going to be coordinating with the ballot measure, the main ballot measure committee, or whether you're going to be working independently from a ballot measure committee. Because again, whether you're coordinating with the main ballot measure committee or whether you're doing independent advocacy is going to dictate which campaign finance reports you file and when. And so keep in mind that the independent expenditure threshold comes up pretty quickly. It's a relatively low threshold. So, you know, you can decide early on, right? Are you going to be working independently, or are you going to be coordinating with the ballot measure committee? And if you're coordinating with the ballot measure committee, it's the ballot measure committee's responsibility to do the disclosures. And so the communication just needs to be clear between you and the ballot measure committee. Okay, I see a question. Okay, I'll get to your question in a second, Margaret. Other practical concepts about campaign disclosures, right? If your organization is raising earmarked funds for a ballot measure campaign, you will be required to disclose contributors on campaign finance reports once you receive a total of $2,000 or more. So again, this is another strategy to think about. Are we going to be raising earmarked funds? If the answer to that is yes, first of all, ask yourself why that's the strategy that you need to take. And if it is, then you want to be mindful of being a recipient committee and be mindful of the disclosure, the donor disclosure requirements as you develop those relationships with your donors. Even if your organization isn't raising earmarked money for a ballot measure, it may still need to disclose its donors and its contributions to the campaign if you're spending, again, $50,000 or more of donor funds. So it's a it's a sizable threshold, but it is something to pay attention to if you do plan on spending a significant dollar amount of donor funds on ballot measure work. If your organization is working with a ballot measure committee, again, the threshold for filing reports is a lot higher, but the committee may need to report the resources you contribute to the campaign. So this is what we were saying earlier. So if you're coordinating directly with the main ballot measure committee and you are not the ballot measure committee yourself, just make sure you are doing accounting and making it easy for the ballot measure committee for their reporting obligations. And again, if your organization is working independently, you will only need to report if you spend $1,000 or more for communications that expressly advocate for or against a ballot measure. So that's the threshold to pay attention to if you're not planning on engaging in coordinating activities. It's not a huge amount, but there are ways that you can engage in independent ballot measure advocacy on behalf of your organization without hitting that threshold, and still engage in valuable ballot measure advocacy. I see Margaret has a point here. At what point does advocacy for more money become lobbying? Yeah, so if you are communicating to legislators about budgets that they have to vote on, so you're asking for an increase in after school programs, and you're talking to those legislators and they are voting on the budget, that's going to count as lobbying. So yeah, so good question. Staff doing work as volunteers. This is a good point, right? So everything that we talk about is about money, right? So if you are using unpaid volunteers, right, you have harnessed the power of the community and they're using their unpaid time. That is not something that you're going to really need to track for California reporting purposes. Now, for the IRS, it does depend on whether you're going to be an electing charity or not. If you are an insubstantial part test organization, you do need to tell the IRS whether you have volunteers that are engaging in lobbying on your organization's behalf. If you're an electing charity, it's just expenses. So if you rely heavily on volunteers, that does not need to be reported to the IRS or count towards your lobbying limit.
But I mean, so many people like over their lunch break or, after work, or I was doing this as a volunteer, which is true, but and that doesn't count if you're doing it as a volunteer, because it is about money. So
yeah.
But what if you get paid time to take lunch?
Yeah, so
but
yeah, I mean that's a good
I mean, that's standard practice.
Yeah, I agree. I think if you are going to be spending time, make sure that it's not on your organization's time. Don't do it during your designated work hours. Make sure that you're really clear that you're doing so on behalf of your own individual capacity. yeah, that's a good, there's always a little loophole there, but yeah, it does need to be not on your own, not on the organization's time for it to be a volunteer for you when you're doing your own work. Any other questions about what we talked about? We've kind of come to the end of our presentation. We do have resources about California campaign finance rules and ballot measure guides specifically. We did recently publish this year a ballot measure advocacy flow chart, which is kind of like a decision tree about like how much money am I contributing? How am I contributing it? Has this triggered a disclosure requirement? So I will circulate that after today. But I do encourage you all to familiarize yourself with what those triggers are. Assess, your organization's independent capacity for tracking these expenditures. You can get involved if you think that your organization doesn't have the resources to do this. Like, let me tell you, you can be a 2-person organization and still be an advocate for ballot measures, right? It's not, it doesn't have to be burdensome, right? So one of the initial decisions that you should all think about is like, how involved are we going to get, and what are the resources we have to meet these disclosure requirements? And again, the thresholds, they're there as ceilings. So what that means is that you can engage, if you're trying to avoid disclosure requirements, you can engage in as much advocacy up into that threshold, and you won't have to worry about like these California disclosure rules. So that could be another strategy for you to consider these thresholds. If you have a team that can help you meet these registration and reporting requirements, then just make sure that you're tracking it and meeting those deadlines, and know what's being triggered and when and why.
So can you say something to people who are like, oh my God, because the whole idea of this is to show you, here's what it takes so you can get involved. You don't have to be scared of it. I mean, for instance, if you have a staff of 20 people and one person is assigned full time to this, that probably keeps you under the limit. I mean, it's only whatever, 5% of your time. And that's a lot of, that's a major contribution to a ballot measure campaign. So it's not that hard to stay under, what you're entitled to do. And people get so scared, like it's of small contributions, or relatively small contributions, because it's quite a bit that you can do.
Yeah, I mean, I think you're exactly right, Margaret. And I think what I hope the biggest takeaway is that you want to be strategic before you act, right? I think that will be like the first, is really the first thing to do, right? Like, sit down and ask yourself, like, how do we track our lobbying expenses? How do we want to do this? Do we want to coordinate? Do we want to do independent expenditures? And do we have the capacity to register and report as committees? If the answer is no, that's okay. You just have to stay under those thresholds, right? So, that's why tracking is going to be such an important component of and making sure that you're checking in with your expenses, regularly. Let's say that you're going to have a big push, closer to the election. So that's where you're really focusing and concentrating your expenses, rather than spending the same amount every month on lobbying communications, right? That can be a way to be strategic about not hitting those triggers. And so there really is a way that you can design your advocacy campaign to avoid these triggers. That is okay also. And it shouldn't be like a deterrent to, to doing any type of ballot measure advocacy.
Yeah, I ran a advocacy organization for 25 years. And we got involved in the budget processes, and we, spearheaded 3 ballot measures, but most of what we did was not lobbying, and we did it all within the context of a C3. So maybe we cheated a little. What can I say? I don't know, but we didn't. We didn't. So we're at the end of our time, and Mallory, Mallory is able to come back. She's able to do another session. She is able, if need be, to do some coaching. She was able, for instance, to help Gloria in Santa Maria with the specific issues related to Santa Maria about running a nonprofit and being a public official. And so, I think, Gloria, should people contact you, or should they contact me, and I get to you?
Yeah, did you mean Mallory? Yeah, I can.
I mean, Mallory.
Yeah,
Sorry.
yeah, you can contact.
I hope you've understood. I am not in the world's greatest space right
No, all good.
I
Yeah,
did not sleep last night, so yeah.
No, you're all good. Yeah, so either one, you can contact Margaret, and she can forward questions, or you can just contact us directly here. Again, this is our technical assistance line. It's not live. You will get a voicemail, but we'll call you back. And we'll try to do it within like 2 days, not on the weekend. And then you can email us at advocacy@afj.org. We have technical assistance folks every day from 9 to 5. And yeah, so this was a lot of information. If this is like your first time hearing all of this, just like, let's exhale together. We at Bolder Advocacy do not expect you to be experts at this, right? What the point of today was just kind of introduce you to like the fundamental guardrails to start thinking about strategically, like, what are some things we have to consider before we start this action? The next step might be to have a meeting and figure out, like how you want to get involved. And one of those steps might also be to schedule a technical assistance call with us to make sure that the plan that you have, developed is one that's going to, be reasonable, not going to trigger these reporting requirements. Or if they do trigger them, make sure that you know exactly what forms you need to fill out. So we can do all the nitty gritty, in our technical assistance. I hope that today just kind of gave you a sense of some of the considerations that are going to go into this. And we're here for you. And we know that you can do this. And we're excited that you're excited about doing this, because you know how important the ballot initiative process is for our communities. It is such an effective form of direct democracy. And we need folks who care about our communities and care about our future generations to engage in this kind of work, because let me tell you that there are corporate interests who are doing this work too on the other side. And so I'm so glad that you're all here looking to get involved and thinking about this upcoming election.
And there will be a horrible ballot measure on the ballot, conceivably statewide, and we'll all have to brainstorm about how to oppose that and how to spend some resources opposing it, which is going to try to constrict our ability to pass local measures. So,
and which one is that?
I can't remember what it's called, but it's the Jarvis Gown, the taxpayers are putting it on the ballot, and it's going to make it, well, it would invalidate a lot of the measures that have already been passed. It's going to make it impossible to gather signatures and only need a 50% vote. It's going to do a lot of terrible things. I'm hoping that somehow people are suing to keep it from being on the ballot. There will be huge opposition, but it is something, it's just a specific thing we should know about. I don't know if it has a name yet.
Yeah, I encourage you all to look at ballot initiative strategic committee. It's BISC, or they're on ballot.org. So BISC is an organization that does a lot of like ballot initiative training resources as well. And they have a Defend Direct Democracy campaign where they're tracking legislation around the country that's trying to like restrict or, burden the ballot initiative process. So they're really the ballot initiative experts after our legal compliance training. I definitely encourage you to check out our partners over at BISC, BISC.
And I do want to say that we're not